Hi, this is Michael Cohen. I'm a Dallas elder law and estate planning attorney, and I'm happy to have Don Crawford Jr., who we for many years did a radio show together. Yes, he's the one who raised his hand, in case you couldn't tell. And for years, he would ask questions of me on our estate planning and elder law radio show, and so he's graciously agreed to continue and ask me questions when we have a topic. Today's topic is going to be probating a copy of a will. What that means is you don't have the original. What is original? The original signature. When you don't have the original signature, it is presumed that the will has been destroyed or revoked.
Hmm.
And so when you have a copy of a will, it's more difficult because of that presumption.
That
So then their question is, what do you have to do that's different? Well, the first thing is you have to not only give when you apply, so when you apply for probate a will, usually when you probate a will, it's usually pretty simple to do that here in Texas if you have done it properly. Typically, there's what's called a self-proving affidavit at the end, where two witnesses sign and swear that you're over 18 and the witnesses are over the age of 14. Somebody was a sound disposing mind and memory, and they sign the will in the presence generally of the two witnesses and the notary, and they swear to the facts. And if you have that, you don't have to bring the witnesses to court. And so probate is usually a fairly simple process here in Texas, unlike other states. Other states may be much more difficult because they make you go through a much lengthier process. But that's the way it is here in Texas. But what if you only have a copy? Well, instead of just giving a copy of the will to the people who are named as the beneficiaries, you also have to give a copy to anybody who's an heir. So, in other words, let's say you had three children and you had two of the children were named in the will, but one wasn't. Well, you'll have to give notice to the one who wasn't in addition to the two that were. If that happens, it's less likely that the will be admitted to probate because that one person who got cut out will probably object. Anyway, so you have to give notice and names and address of all the heirs at law. Heirs at law are determined by the estates code. The Texas Estates Code says who your closest relatives are. And it divides things up on real estate versus community property and personal property and how things. There's a whole law saying this is who the heirs are and what percentage, etc. So everybody who's an heir must get a copy. So let's say you even had that child, one of those children had died and had children of their own. Well, those grandchildren in that example would be have to get notice. And what if they're too young? Then you have to serve. How do you serve somebody who's too young? You have to have a representative and maybe have guardianship, all sorts of different things. Well, anyway, and how do you have citation? How citation must be served. So you have to have, usually you have it at the courthouse, but there could be a waiver of citation. Okay, so the heir or beneficiary could waive their right to be to get, they have it, say they've gotten a copy of the will, maybe they agree to who the executor or administrator might be. And then the third thing is you have to prove why you couldn't find the original will. Why can't you find it? Because there's a presumption of destruction or revocation. So what would that be? So, for example, we had one recently, or we have one going on now, which says, well, the person was elderly and had some dementia, and we think that they just may have accidentally either misplaced it or destroyed it by error or mistake. Could be any number of things. We saw the dog eat it. I don't know. So, and I know, and so I know that your Don Crawford Jr. has a dog named Oreo, and he's keeping a watchful eye over Oreo as we speak,
he's
because
under, he's under my feet as we talk right now. So
I think just as long as he didn't have that will in his mouth right now, you're in probably in better shape.
we're good. I meant to ask you about that. Didn't you once tell us that many years ago on the radio show that Tina Turner had a will or something to that effect on her under her couch cushion?
That was Aretha Franklin.
Rita Franklin. Okay.
Yeah, originally they couldn't find the will, and I said that her children had gave her no RESPECT, or she gave
Right.
them no RESPECT,
Right.
which meant that it meant more. Quite frankly, it made it much more difficult. And then, so after about a year, not only did originally they thought there was no will, and then they found one under the cushions and another one someplace else, and it was handwritten, and the four children who were the heirs who were got along before, by the time it's all said and done, unfortunately, they're at loggerheads. They're not talking, some are not talking to each other. And this is what happens a lot of times, unfortunately, when one says, I should be in control, or I should get more, or this or that. And unfortunately, a lot of greed. And that's the way it is.
I think you asked me too once. I don't know if it was regarding Aretha Franklin or another matter, but I think you asked which one counts the most if you can't tell the difference or there's no other indication that one is more valid than the other. And I think you said to me the latest one, the one that was written the last.
Yeah, unless you could presume that there's something wrong. So, in
Right.
other words, if somebody lacks sufficient mental capacity, or let's say that they had undue influence, there could be an issue with that. So, let's say one son was in with the deceased and said, "Hey, I think you should give it all to me." Then that would be. Remember, I told you that one time about I had a client, the lady with no teeth, and I said to her, who she was with a daughter, and I said, can you tell me who you want your home to go to? And she spoke gibberish, and I said, I'm so sorry, I can't understand you. Can you say that again? And again, I asked her who she wanted to give her home to. She had 10 children. And she, blah. I said, gosh, I can't understand you. I must be getting older. Maybe it's my hearing. Can I ask you one more time? And again, I couldn't understand. So finally, I said to her daughter, I said, did you understand yours? She said, yes, of course. I said, well, who did she say the house goes to? She says, it goes to me. Okay. All right. That's undue
Very good.
influence.
Yeah.
You know, so there you go. You say, well, I think we'll pass it. Of course, you could ask them to put it in writing or something like that. And usually that's a reason why you should have somebody who might be a beneficiary in another room or not with them at the time, because
Mhm.
undue influence, and there's three things: undue influence, duress, and lack of capacity are the three different reasons why people often contest. So even if it's a last will and testament, if it's something where there's questionable capacity, so often we have people who have questionable capacities have a doctor sign an affidavit, usually a specialist in the mind, so that we can determine if the person had enough capacity. But usually you're right, the last will revokes our prior wills. Sometimes there's causals, which is just like an amendment to the will.
You can't be
Time it's
diligent enough when you're doing this kind of work, and you need to make sure that there are no conflicts of interest, there are duplicate wills, that there's a, is it a wet signature, Michael, I guess they call it, or something like that, where it's signed and then that makes it official. And if you don't have an official will, trust, or other, any documents that Michael provides, you need to go to his next workshop, which is coming up anytime soon. I don't know what the date is, but sometime in the next month or two. And you should just call Michael's office at 214-720-0102, 214-720-0102, or go to dallaselderlawyer.com, dallaselderlawyer.com to get more information. Michael?
yeah, those workshops are free. They're usually on Saturdays. Um, we have them every month. And so even if you can't make the next one, you can try the one after it. I do want to add one or two more things. If
Sure.
you don't have a copy of a will, you'll have to get witness testimony.
Right.
And that means either the person who was signed the will, if it was, you know, if it was a self-proving affidavit at the end, that makes it a little bit easier if you can find them. A lot of times they're older wills, and so it's more difficult. And so then you have to have some sort of credible witness who's heard or seen the will. And sometimes you have to have two disinterested witnesses, and sometimes it depends on the court that you may have to have an ad litem, another attorney representing. So it gets to be a lot. So where there's a will, there's a way, but it's a lot more difficult, and a lot more expensive when you have to probate a copy of the will. Well, anyway, I'm not going to belabor that, but I just wanted to let people know that there is a way, but it is more difficult. In any event, like you said, if you want to go to the next workshop and learn more, I don't know that we've ever had a question, and we've been doing the workshops for, oh gosh, 15 years. That it seems like that. I don't think we've ever had a question, how do you probate a copy of a will? But since we're seeing this from time to time, I thought it was an appropriate subject. Well,
Good.
thank you, Don. Is there any other questions that you have of me?
Sure.
Well,
Good.
until next time.